Telemedia?
Yes.
Okay, Chelmsford Telemedia. It is 1 o'clock on September 29th, 2022, and I will call this meeting of the Chelmsford Select Board to order. Would you please join me in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So I have confirmed immediately prior to this meeting that the employee wishes to continue this in open session, so we will not be adjourning to executive session. For the record, our attendees include the town manager, Paul Cohen, and the 5 select board members, in addition to Joseph Fair, who is from KP Law and is counsel to the board. With that, I'm going to turn this over to Joe to frame the meeting for us.
Thank you, Madam Chair. Thank you, Madam Chair. The purpose of the meeting today is it's essentially being held for the purpose of determining whether or not to discuss complaints that have been raised regarding the town manager and to determine whether or not the board believes there's reason to convene a disciplinary hearing. Today's meeting is just simply to discuss the nature of the complaints. It's not for taking any actual disciplinary action in this matter. It's just to talk about the general nature of the complaints and if there's a desire among the board, a majority of the board, to advance after hearing the nature of the complaints as well as the town manager's response. There's a desire to bring this forward to a disciplinary hearing. If the board were to determine that a disciplinary hearing is needed, there would be a separate notice sent to the town manager in advance. Similar situation is today. He would have to be given notice as well as what the allegations are that he would be essentially the allegations of misconduct that would be the purpose for which that disciplinary hearing would be held. That would be for a future meeting, but today's meeting is just to discuss the general nature of the complaints and whether or not the board feels there's sufficient reason to move forward with the next step.
Okay, so with that, I will open it up for comments from the board or Manager Cohen.
Madam Chair, I have a presentation I'd like to provide to the board, and I'd ask the board's indulgence to hear the full presentation, and I have copies of my presentation for the board.
Sure.
Thank you.
Thank you.
Thank you, Paul.
Thank you.
You. Thank you. The Select Board scheduled today's executive session to discuss complaints made against me by Select Board members. These complaints relate to my conduct and statements concerning the unfair labor practice charges that the New England Police Benevolent Association Local 20 filed against the town. I was offered the opportunity to hold today's Select Board meeting in executive session. Instead, I have decided to have this meeting held in open session, as is my right under the law. My integrity and actions are being questioned by some members of the board and by some members of the community. I feel that the residents of Chelmsford are entitled to transparency. I will provide as much information as I can. I believe that these actions conforms to the town's visions and values. When I walked into the Senior Center on the night of February 4th, 2019 special town meeting, I expected that the town meeting would fund the Police Superior Officers Union Arbitration Award. When the special town meeting was called for another purpose, I placed an article on the warrant hoping to fund an arbitration award. In the days prior to the town meeting, I kept pursuing the receipt of the arbitration award in order to bring it to town meeting. When the arbitration award was issued on the day of the town meeting, I acted quickly to disseminate the award and to obtain the town accountant's calculation of the amount of funding to be requested at town meeting. I did not contact any Finance Committee members or town meeting representatives in an effort to defeat the award. I wanted the contract settled so that I could incorporate the terms of the agreement into the subsequent fiscal year's police department operating budget that I needed to present at the upcoming spring annual town meeting. I have worked tirelessly for this community during the past 15 years. My coworkers, volunteer, committee members, and residents have done much to make Chelmsford a great community. I serve as a member of the Rotary Club, and I am present at many community events. What motive would I have to knowingly engage in unlawful conduct during the arbitration proceedings? I would not have risked my reputation in my 32-year career. There was no personal gain for me. I did not act to hinder previous arbitration awards. I do not have a history of violations in other labor proceedings or a trail of employee grievances. During the past 5 years, the town employees in the Facilities Union, Cemetery Union, Highway Union, and Clerical Union have voted to dissolve their union affiliations and become non-unionized employees. I am not aware of this happening in any other comparable Massachusetts municipality. I do have a reputation of adhering to the collective bargaining guidelines that have been provided to me by the Select Board, and I strongly defend the interests of the town of Chelmsford during collective bargaining. I respect the police sergeants who serve this community so well. I am sure that Police Chief James Spinney will attest, as would former Chief James Murphy, that I have always been supportive of the Chelmsford Police Department. I worked diligently before and after the Police Superior's Officers Union arbitration proceedings to reach a labor agreement. However, as I detail in this written report, I could not do it alone. In my very limited history with the JLMC arbitration process, I found that each of the neutral arbitration panel members conduct their process differently in a system that is intended to provide flexibility. Prior to reading the hearing officer's decision, I did not know that I should have disclosed that Labor Counsel Mark Terry had engaged in communications with arbitration panel management member Andrew Flanagan during the arbitration panel deliberation period, or that I should have disclosed that Labor Counsel Mark Terry had authored the dissent on Andrew Flanagan's behalf. Based upon the circumstances which I describe in this report, I do not find it reasonable that I should have known. In labor proceedings such as this JLMC arbitration hearing, the town council commands the proceedings. The then newly appointed Labor Counsel Mark Terry was appointed by the Select Board, not the town manager. Similar to the town accountant, he had the independent authority to conduct the proceedings and to report directly to the Select Board. I do not think that Labor Counsel Mark Terry or Andover Town Manager, Management Representative Andrew Flanagan would also knowingly risk their reputations and livelihoods for this arbitration proceeding. The Select Board appointed Special Counsel Brian Harrington to investigate the town's actions in the arbitration proceedings. His statements to the board provide insight into the practices at the JLMC. I asked Select Board Chair Virginia Crocker-Timmons whether she had received any written complaints from members of the Select Board pertaining to this matter. She informed me that no written complaints had been submitted. Without being provided with any specific information regarding Select Board members' concerns, I have prepared a question and answer format of possible concerns that may arise when reading the Department of Labor Relations hearing officer's decision. In addition to the decision, information is available from the transcripts of the 8 days of hearing testimony, as well as from the hearing documents. There is also sworn testimony from others who were involved in this matter. The Select Board members were provided with copies of the hearing transcripts, which are public records. Question 1. The hearing officer's decision found that the town violated state law when Joint Labor Management Committee Representative Andrew Flanagan engaged in ex parte communications with the town's Labor Counsel, Mark Terry, during the arbitration panel's deliberation period. Do you feel that you were in any way responsible for this violation? No. The town's involvement in the JLMC arbitration process was managed by the town's Labor Counsel, Mark Terry. The Select Board appoints Labor Counsel, and Counsel reports directly to the board, not to the town manager. Attorney Terry was a subject matter expert for the JLMC proceedings. His law firm was compensated at a rate of $200 per hour for legal services. Attorney Terry managed the town's response during the arbitration proceedings. His actions and conduct during the arbitration hearing process were not directed either by me or the Select Board. He testified that he prepared the town's presentation at the arbitration hearing, noting that his office did most of it. If I were to have requested that Attorney Terry undertake any improper or illegal action, he would have had the authority to refuse any such request and to directly contact the Select Board. This was how Attorney Terry operated during the arbitration process. Attorney Terry testified that he had participated in other prior JLMC arbitration proceeding cases not involving Andrew Flanagan. He noted that on multiple occasions, he had communications with the management panel representative after the time that the record was closed and briefs had been submitted outside of the presence of union representative and outside of the presence of the other panel members. He also recalled receiving a copy of the draft award in those cases. It was his assumption of how the practice at the JLMC worked. It was Attorney Terry's understanding that the management and labor representatives on a JLMC arbitration panel are additional advocates for the labor and management positions in the arbitration. And as you note, I'm not going to read the cites from the transcripts, but they're there. He explained that in his view, the communication with the management representative was intended to be ongoing up until the award is issued and the matter is closed. The Select Board's July 29, 2019 executive session meeting minutes document that the Select Board brought in attorney Brian Harrington to provide an independent report on the union's allegations. The minutes contain the following, quote, Attorney Brian Harrington introduced himself, noting the experience he has with all aspects of the Joint Labor Management Commission. And I note parenthetically, Attorney Harrington had practiced before and worked for the Department of Labor Relations. Mr. Harrington, continuing from the minutes, Mr. Harrington then addressed several of the allegations against the town. Quote, the fact that the management panel member, Andrew Flanagan, shared confidential information with the town is somewhat unusual. However, at the time of the action, it would not have had any influence on the award decision. Sharing the draft decision is not uncommon. For the town to supply additional arguments attempting to sway the final decision is commonly done. End quote. In addressing the allegation that Town Labor Counsel Mark Terry wrote the dissenting opinion, Mr. Harrington stated that this happens more often than not, and it did not affect the outcome of the award. Attorney Harrington met with the Select Board in executive session on January 20th, 2020, to present his report regarding the union's allegations relating to the JLMC arbitration process. The executive session meeting minutes contain the following. Quote, Mr. Harrington chose to present most of his report orally, dealing with three major topics: conduct between the Joint Labor Management Commission, arbitration hearing, and the issuance of the award. The union alleged impropriety of communications between the management representative on the JLMC panel, Andrew Flanagan, and town officials, specifically Town Labor Counsel Mark Terry and the town manager. Mr. Harrington noted that there is no JLMC settled practice governing that type of communication. In his opinion, emails from Mr. Flanagan should not have been released. However, he sees no liability by the town as there was no apparent ill intent. If experienced attorneys who work with the JLMC were not of the opinion that the ex parte communication between Management Representative Andrew Flanagan and Labor Counsel Mark Terry violated state law, it is not reasonable to hold me responsible for this violation. Question number 2. However, you were aware that Labor Counsel Mark Terry was in communication with Andrew Flanagan. Why didn't you intervene to stop the ex parte communication? I was not aware that the communication between Andrew Flanagan and Mark Terry was inappropriate or unlawful. As noted in the hearing officer's decision, in 1987, the state legislature enacted legislation to establish the JLMC for the purpose of resolving collective bargaining disputes between municipalities and their police and fire unions. Volunteers from municipal management organizations, members of police unions and fire unions assist the JLMC in mediation and arbitration. The footnote on page 8 of the hearing officer's decision clearly states, quote, the JLMC's rules and policies do not address the conduct of committee members while serving on a tripartite arbitration panel. In my limited experience, consisting of 4 arbitration panels during my 30 years of municipal management, I have found that neutral arbitrators run their hearings differently. The police patrol officers arbitration hearing that immediately preceded the Superior Officers Union arbitration hearing illustrates this point. During that three-party arbitration panel, after the arbitration panel received the arguments from both the town and the union, the neutral arbitrator met repeatedly with each party in separate rooms until he arrived at a decision. Joint Labor Management Committee Senior Staff Representative for Management George Driscoll testified during the hearing that it is left to the arbitration panel members regarding how to handle things. I was aware that Attorney Terry had extensive experience over 2 decades as a municipal labor attorney. He is a partner at Myrick O'Connell, which is a law firm that has provided legal services for Massachusetts municipalities. I was aware that Attorney Terry had previously provided labor services to the town of Chelmsford during Manager Lynch's tenure. I knew that Attorney Terry practiced as a municipal labor attorney, regularly practiced at the JLMC's arbitration and other proceedings, and had a solid reputation. It never occurred to me that Attorney Terry would violate the state's labor laws. I did not have a personal relationship with Management Representative Andrew Flanagan. Andrew Flanagan testified that beyond the JLMC proceedings, he had never worked with me. I understood that Andrew Flanagan volunteered as a JLMC management representative. I expected that he had been sufficiently trained by the JLMC regarding his responsibilities. I do not have any reason to question his character or experience. Question 3. Why did you not question Attorney Terry's decision to draft the dissenting opinion? As I detailed in my testimony during the labor hearing, when I was contacted by Attorney Terry regarding the drafting of the dissent, my immediate reaction was to ask him, why wasn't Andrew Flanagan writing the dissent? Attorney Terry informed me that Andrew Flanagan was busy and did not have time to draft the dissent prior to the scheduled issuance of the arbitration decision. It was my understanding that Attorney Terry would be writing a dissent that reflected the discussions that he had been having with Andrew Flanagan. Andrew Flanagan testified that he had never contacted me about drafting a dissent. He further elaborated that he had never heard from me about what should be contained in the dissent. I did not edit or modify the draft copy of the dissent that Attorney Terry emailed me. I was not aware that Attorney Terry's drafting of the dissent was unlawful. Question 4. Did you mislead the Finance Committee in town meeting by not disclosing that the arbitration award had been influenced by the town's conduct? No. I did not do anything underhanded, deliberately conceal any information, or misrepresent the truth. And the hearing officer did not say that in her ruling. The hearing officer's decision notes that the union's complaint do not allege that the town failed to support the arbitration award when they presented it to the Finance Committee in town meeting. The Finance Committee meeting minutes of February 4th, 2019, which is immediately prior to the special town meeting, confirmed that the information that I presented regarding the arbitration award was factual and that I supported the award as required under the law. The hearing officer's decision found that the town meeting representatives were clearly aware that there was a lengthy majority opinion and understood the award associated therewith. The video of the February 4th, 2019 special town meeting reveals that I favorably presented the arbitration award. I summarized the award. I noted that this was the third of 3 arbitration awards for the town's public safety unions. I did not refer to the dissent in my presentation. When questions are asked regarding what happens if the award is voting down, whether it is unusual to have a dissent, and the amount of time and effort involved in bargaining, Assistant Town Manager Michael McCall provided the answers. I explained that Michael, who serves as a management representative for the JLMC, can best answer these questions. He provided accurate and truthful answers. As I have previously explained, I was not aware that the ex parte communication between Andrew Flanagan and Attorney Terry was unlawful or inappropriate. My understanding was that Attorney Terry drafted the dissent based upon his ongoing communication with Andrew Flanagan. I expected that the dissent would be reviewed and edited and submitted by Andrew Flanagan. It is a common practice for an attorney to draft documents for another's review and signature. I did not mention that the arbitration award had been influenced by the town's conduct because I was not aware that the town's conduct was unlawful. Based on the information that I have already provided, it is not reasonable for me to have known that the town's conduct was unlawful or to have even suspected that it was unlawful. Question 5. Are you responsible for the town's failing to provide information to the union regarding the release of the Select Board executive session meeting minutes relative to collective bargaining during this period? No. As town manager, I was not responsible for this decision. The request for public records was handled by the town's Labor Council. Again, the town has historically sought guidance and continues to seek guidance from town council when presented with such requests. The Select Board's October 7, 2019 executive session meeting minutes read as follows. Attorney Terry also updated the board on the complaint from the union to access executive session minutes related to these negotiations, which have not been publicly released. Offers to provide segments of the minutes in or redacted versions were refused. He expects that this complaint may be combined with the earlier complaints which were forwarded to the DLR for the February 2020 hearing, close quote. Question 6. What actions did you take to resolve the impasse? Following the failed vote of the February 4, 2019 special town meeting, I made repeated efforts to reach an agreement with the union. When the union vice president, current president, appeared at my office in the aftermath of the failed vote, Assistant Town Manager Michael McCall and I offered to meet with the union as soon as possible in an effort to resolve the matter. Our offer was rejected, and we were told that this was personal. I am sure that if asked, Michael McCall would confirm that. A month later, Attorney Terry recommended that the town begin negotiations anew with the Superior Officers Union in an attempt to reach an agreement for a 6-year period, which would have covered the arbitration award period in the subsequent 3 years. Again, this is detailed in the Select Board Executive Session meeting minutes of March 11, 2019, and all these minutes are publicly released, so I'm not violating any sanctity of executive session. I agree that this approach should result in a win-win outcome in which both the town and the union could be satisfied. The April 8, 2019 Select Board Executive Session meeting minutes revealed that Assistant Town Manager Michael McCall informed the Select Board that the union representatives had refused to bargain since the time that the arbitration award was voted down at town meeting. The May 6, 2019 Executive Session Select Board meeting minutes read that Mr. Cohen and Mr. McCall reiterated that they are continuing their attempts to restart contract negotiations with the union to no avail so far. The July 8, 2019 Select Board Executive Session meeting minutes read as follows, quote, Mr. Cohen reported that the superior officers sergeants have not responded to efforts to restart negotiations. A mediation session was held on September 5, 2019. The mediation session was unsuccessful. The union's proposal continued to be that the parties should come to an agreement consistent with the February JLMC arbitration award, and then it would negotiate for a second 3-year period. The town continued to reject that proposal because it was not a negotiation. The parties agreed to schedule a mediation session on September 17, 2019. At the September 23, 2019 Select Board Executive Session, Labor Counsel Mark Terry summarized the 5-hour mediation session that occurred on September 17, 2019. The goal of the mediation session was to reach an agreement for a 6-year period. The minutes read as follows, quote, Attorney Terry noted that the labor mediator recommended that the union accept the town's offer. However, they refused. Little progress was made throughout the day, close quote. At the March 5, 2020 Select Board Executive Session meeting, Labor Counsel Brian Mazur referred the board to his memo dated February 28, 2020 that described the January 27, 2020 events at the Department of Labor Relations offices pertaining to negotiations with the union and the initial DLR hearing. The executive session meeting minutes read as follows, quote, Selectman Antul asked Mr. Mazur if the situation had become too acrimonious to be settled. Mr. Mazur replied that he believes that this is the case, stating that the town's most recent offer to the union actually exceeds the dollar amount that was awarded by arbitration in February 2019. Negative feelings have escalated to the point that Mr. Mazur speculated that we may have reached a different negotiation result with a different individual, end quote. On March 20, 2020, Labor Counsel Mazur reached out to the union's counsel to inquire as to whether there was any interest in re-engaging in settlement mediation discussions. Counsel for the union responded the same day and advised that he would follow up the following week. Counsel for the union did not follow up with Attorney Mazur the following week. On April 13th, 2020, the DLR appointed mediator John Murrah reached out to the parties to resume mediation. Attorney Mazur contacted Mr. Murrah to note that in light of the deteriorated economic conditions as a result of the COVID-19 pandemic, the town could not match its latest proposal made at mediation. Mr. Murrah contacted Labor Counsel Mazur 4 days later to inform him that the union viewed the town's proposal as, quote, regressive, and that they would not be responding. The June 1st, 2020 Select Board Executive Session meeting minutes read as follows, quote, Mr. Cohen noted the efforts of Labor Counsel Brian Mazur to come to an agreement with the union. Offers included settling for the arbitration award that was rejected at the February 4th, 2019 town meeting for the fiscal years 2017 through 19, then adding similar language that was agreed with the police patrol officers for the fiscal years 2020 through 2022. The union had refused to consider this latest offer, stating that any offer must include a reduction in the current gap between their wages and those of the lieutenants. Mr. Cohen noted that the town's offer would reduce the disparity to the point that it was 20 years ago. He also stated that this offer would provide a total increase of 2% more than any other union had settled for, end quote. The union's response is to accept the first 3-year agreement, fiscal year 17 through 19, as awarded by the arbitration, and then negotiate on the next 3-year period. Mr. McCall stated that the arbitration that has been ongoing with the Joint Labor Management Committee with other communities has resulted in settlements less than previously sought, primarily due to concerns that the COVID-19 crisis had caused relative to the economy and municipal finances. Mr. Cohen stated that Labor Counsel will continue efforts to resolve this impasse, end quote. An informal effort was made to resolve this labor impasse, and it occurred at the police station on October 26, 2020. Police Chief James Spinney and Select Board member George Dixon were present, along with the union president and vice president. Prior to the date of this meeting, I contacted Chief Spinney to suggest that perhaps he and Deputy Chief Dan Ahern may be able to have a productive discussion with the union representatives without me present. Chief Spinney contacted me the following day to inform me that the union president insisted that I be present for any contract discussions. The October 26th meeting lasted for approximately 90 minutes, but was unsuccessful. The gulf between the parties was too large. Labor Counsel Brian Mazur was present at the Select Board's April 27th, 2022 executive session meeting. The meeting minutes read as follows, quote, the group discussed exploring alternative approaches with different people involved to resolve the superior officers' negotiations in advance of the Department of Labor Relations ruling, even if the probability of success was low. Manager Cohen could delegate this to Attorney Mazur, Gene Parzali, and perhaps one more member of his staff, such as John Souza. Attorney Mazur will reach out to the superior officer's attorney to explore this possibility, end quote. On May 12th, 2022, Labor Counsel Brian Mazur emailed the union's counsel with an off-the-record proposal to resolve the pending unfair labor practice charges between the parties. The union did not provide any counter offer. Attorney Mazur emailed me the following on May 3rd, 2022. Quote, I believe that regardless of what you propose, they will never make a counter, end quote. I replied as follows, quote, I agree with your assessment. I think that a reasonable resolution can be reached. However, I cannot do it alone, end quote. Question 6, the final question. Is there anything else that you would like to state to the Select Board? The Joint Labor Management Committee's mission statement contains the following language, and I'm quoting from the website. The JLMC rejects the view that a single standard procedure is the best way to resolve every dispute. The committee designs procedures appropriate to the particular case in consultation with the affected parties. Internally, it may use field investigators, senior staff, the vice chair or chair, with various labor and management committee members in a variety of procedures. It is a canon of the committee to be inventive and imaginative in the design of procedures for a particular case, even in the course of dispute as it unfolds or changes direction. The committee typically develops a series of steps or procedures in a dispute, each designed to enhance the prospects of settlements. These processes seek to enhance the voluntary settlement of disputes by urging parties to settle by themselves at each stage before resorting to the JLMC. The following is evident from the Department of Labor Relations hearing testimony and the hearing officer's decision. The JLMC has no rules that govern its procedures to the conduct of management or labor committee members who have been assigned to a case. And this was testimony from George Driscoll, the senior management rep at JLMC. The JLMC does not provide committee members such as Andrew Flanagan with any specific direction as to how they should perform their responsibilities while serving on a tripartite arbitration panel. This is found in the hearing officer's decision, page 8 footnote. And also from George Driscoll's, again, the senior management rep at JLMC, his transcript on pages 193 and 199. The arbitrator, Beth Wolfson, did not provide any instruction to Andrew Flanagan regarding the conduct of the arbitration process. This is noted in the hearing decision on pages 9 and 10. The ex parte communication was initiated by Andrew Flanagan. Andrew Flanagan explained that when he received the neutral arbitrator's draft decision, he initiated an outreach to Attorney Terry. His discussions were exclusively with Attorney Terry. He did not speak to me. He did not send me the draft award. He did not otherwise contact me. And he did not ask Attorney Terry for my thoughts. Again, this is Andrew Flanagan's testimony. Attorney Terry confirmed that Andrew Flanagan initiated contact during his testimony. Andrew Flanagan provided the draft arbitration award to Labor Council, but did not send it to the town manager. Andrew Flanagan did not directly contact the town manager relative to the draft award. He did not ask for or receive the town manager's thoughts about the draft award. The town manager did not participate in any telephone conversations, emails, or text messages between Andrew Flanagan and Labor Council Mark Terry. And that's based on Andrew Flanagan's testimony. The town manager did not have any substantive conversations with Andrew Flanagan during the approximately 4-month period after the date of the arbitration hearing through the issuance of the award. Labor Council Mark Terry raised the concept of Andrew Flanagan issuing a minority decision. Andrew Flanagan never spoke to the town manager about drafting a dissent. Again, that's Andrew Flanagan's testimony and Mark Terry's testimony. The town manager learned of the dissenting opinion from Labor Council Mark Terry. Labor Council Mark Terry testified that Andrew Flanagan's conduct following the filing of the briefs and the discussions pertaining to the draft award were not inconsistent with his understanding of the role of arbitration panel members throughout his 20 years of practice before the JLMC. Andrew Flanagan's conduct in this matter was investigated by the Department of Labor Relations. He was never brought up on any misconduct charges, and the DLR did not issue any formal findings that he engaged in any wrongdoing. That comes from Andrew Flanagan directly during his testimony. I am not aware of any Department of Labor Relations actions taken against Attorney Mark Terry regarding his actions in this matter. The town manager did not engage Finance Committee Chair James Clancy in any discussions regarding the expected terms of the arbitration award prior to the issuance of the award on the day of the special town meeting on February 4th, 2019. And that was from Jim Clancy's testimony. The town manager did not have any communications with members of the Finance Committee from the time that he emailed the members of the arbitration award in the Finance Committee meeting that was held an hour before the special town meeting. Again, that's James Clancy's testimony. The town manager did not reach out to any town meeting representative to influence their votes on whether to fund the arbitration award. The town manager did not speak negatively about the award at the Finance Committee meeting, and that's found in the Finance Committee meeting minutes. During the special town meeting, the town manager did not refer to the fact that management committee panel member Andrew Flanagan had voted against the award. And that's evident from the video of the special town meeting. The town manager did not have any advance knowledge that Finance Committee Chair James Clancy was going to read the dissent at the special town meeting, or that the Finance Committee was going to distribute copies of the dissent at the special town meeting. The town manager's presentation of the arbitration award and request for funding at the February 4th, 2019 special town meeting did not differ from his presentations at the previous two town meetings pertaining to the arbitration awards from the firefighters and police patrol officers unions. And again, that's available by watching the town meeting videos. The town manager's presentation of the arbitration award at the special town meeting did not make any reference to the dissent. Again, that's found in the video of the town meeting. The town manager did not take any effort to conceal or sanitize the entry on the town's legal invoice from Attorney Terry's law firm. It read, "Draft dissenting opinion from management panel member. This legal bill is a public record," and found in the Myrick O'Connell legal invoice. And finally, the town manager made repeated efforts to reach labor agreement following the failed vote at the February 4th, 2019 special town meeting. Thank you, Madam Chair and board members, for taking the time to allow me to make this presentation. As you can imagine, this took me an extensive amount of time, and I feel it's very important to summarize for the board as well as the community what has transpired in this matter. Thank you.
Thank you, Manager Cohen. I'll open it up for comments from the board. Questions?
I have a question about, and I wasn't privy to some of this, but the comments that in here that talk about Harrington, the investigation. Are those meetings, were those released?
Yes. The answer is yes. Those were released. As I stated earlier, I am not putting out information that's held in executive session. That is publicly available.
I would like to clarify, Attorney Harrington was not hired to conduct an investigation. He was hired to advise the board and to help give us an independent assessment at that given point in time.
All right, and again, just so the public is clear, I was recused from all of this, so this is stuff, obviously, that and Mark was not here, so to clarify this. Was there any, and I know the answer to this question, but I was in the room when something was handed out that was read, but was there anything that, I know there was a report done, but.
That document has not been disclosed to the public.
Okay.
Madam Chair, if I may, what I can describe is Attorney Harrington, as I noted in my comments, made his report mostly orally to the board. And that was deliberate, and my recollection is that he said that because he did not want that report to the board to basically get out and otherwise. That explains why he gave the initial report verbally to the board. And I believe my recollection is solid on that one. That's what he told the board, is it was a deliberate effort to provide a verbal report to the board. And again, what I quoted one from was the select board meeting minutes.
And then, Paul, as I look through the rest of your notes here, I personally don't ever, from question 4, I get what you're saying, question 5, I get what you're saying, 6. To me, that was a long history since, but that has nothing to do with what, I get it's a history, but what we're here today for is the complaint.
Well, if that's the case, I'll apologize. It's to date, the board has had 2 meetings, regularly scheduled meetings, since the date of the release of the hearing officer's decision. And on those 2 occasions, the board has not had any public commentary to the community to provide context or explanation or whatever to the community. Instead, the board's first action is to meet with me regarding possible violations that I may have occurred, although no written violations have been presented to me. So I thought it was important to summarize it, to provide some context in history for the board members, some of which who weren't involved in all this, but also for the community, who obviously, many of which are interested in this matter, and I feel that my credibility has been dangling out there in the breeze, without any response, and therefore I thought it appropriate. So I apologize if you feel that I went astray from the intent of this meeting, but again, I didn't know what the board wished to discuss with me.
I have a question. What specifically is the complaint and who made it? Why we're here?
I received a verbal request
Okay.
from Ken and George, and I also felt that this was an appropriate meeting to have, given what the ruling was, that we should get together and discuss this as a board.
So it was nothing specific?
And the complaint was articulated in the letter that was sent to Paul that you all saw, regarding, Attorney Fair has it, regarding the matters surrounding the DLR ruling.
Okay.
And discussing the town manager's role in that.
Okay.
And I have a copy here if you need to see it again, Mark.
No, I don't
Okay.
need to see it.
So I want to thank Paul for presenting this very lengthy and comprehensive report. I had some of the points I wanted to make were already made in that, and I guess the first one is, who initiated this ex parte communication, and clearly it was not Paul. That was stated in the decision itself, that clearly it was not Paul. His involvement, from reading it, it looks to me like he was following the lead of town council, which I think we would expect him to do. The fact, as Paul had said, that this hearing officer determined that what our then town council did was not lawful or not correct. There's no way he could have known that. I think it's kind of it reflects poorly, I think, on JLMC for not having some procedures and policies and rules and regulations in place. So shame on them for not being clear about that, again, which is also stated in the hearing officer's report decision, that there were no rules. So it's kind of confusing to me how she can say that something is unlawful when there are no rules saying what's lawful and what isn't. So to me, quite frankly, I don't think there is sufficient reason to have a disciplinary hearing for the town manager based on what's in this decision. I think that if there's fault, it lies with our then Labor Council and Andrew Flanagan, the JLMC member, who clearly they corresponded quite a bit, and the town manager was peripheral to that.
Anyone else?
Just to what Patrick said, so just again, reading out of the decision, it's widely accepted that the arbitration proceeding is under the jurisdiction and control of the arbitrator, subject to the rules and procedures they may be jointly prescribed by the parties, and that, in the arbitrator's estimation, allow a full and fair hearing. It goes on to say, the conduct of the arbitration proceedings is under the arbitrator's jurisdiction and control. They follow the code of professional responsibility for arbitrators in labor management disputes. So I went and looked that up, printed it out. An arbitrator must make and provide fair and adequate hearing with assurance that both parties have sufficient opportunity to present their respective evidence and argument. When you read this, and this is the professional responsibility for arbitrators of labor management disputes, it's given out, page 10, all significant aspects of the arbitration proceedings must be treated by the arbitrator as confidential unless this requirement is waived by both parties and disclosed as required and permitted by law. So it specifically says it's confidential unless the person running it says it's not, or requested and then told to all parties that stuff is going to be shared.
Well, I think it also says several times in the hearing officer's decision, and I don't have the page numbers here to reference, or that code that I was not aware of, and obviously the JLMC doesn't follow it because they haven't followed it in other situations, as we've heard. So it just seems to me that even if that were the case, it's not Paul that violated the confidentiality.
Well, one of the other comments she made early on in the brief talks about having to take the totality of the actions involved. And one of the things that I question is, if Mark Terry goes back to Flanagan and says the town agrees to a 2% or 1.5%, Mark does not have the ability to make those offers. He had to have come back and spoken with Paul about those offers if he's going to write them in the dissenting opinion or any of this. So there had to be some communication between Paul, Mark Terry, and even though there's no direct communication, which Paul laid out between him and Flanagan, just like we abide to the rules that if you talk to me and then I go talk to George and George talks to Mark, that's a meeting. This is, to me, what appears to have happened there. Terry reached out to Paul, reached out to Flanagan, Flanagan spoke to Terry, and that went back and forth without any acknowledge of the arbitrator and the other people in the group understanding that.
Okay, but it also said in the hearing officer's decision that they were, the hearing officer, the neutral arbitrator, Wolfson, I don't remember her first name, wanted the groups to keep communicating, to keep negotiating, and try to come to a resolution before they issue the award. Well, how else are they going to do that other than coming up with some options? So they did that, as was clearly stated in a decision, until basically 2 or 3 days before it was issued. So I give them credit for that, and I think the hearing officer and the arbitration panel should have given them credit for that.
The other thing that I may point out to provide you with some perspective, Selectman Lefebvre, is these same individuals were involved in the mediation session prior to the arbitration session. So Attorney Terry was very familiar, in fact, prepared the mediation material, briefs and arguments and everything as well. So you're assuming that something that took place that wasn't the case. Basically, Attorney Terry had the history of the negotiations, and I believe relied upon that for those communications with Andrew Flanagan.
Does somebody else want to speak?
Yeah, I mean, I can mainly go by the documentation that's there, and Ken, I'm actually not aware of the document that you just referred to. But from looking at everything, and I do believe that the policy is to have it somewhat loose so that the parties can potentially come to some kind of a resolution before the JLMC has to come down with one. And the fact that Andrew Flanagan reached out first to Mark Terry, I think signaled that that's the way that they were going to work. And I think based on that, that's why Mark Terry started to engage back with Flanagan to get more information to try to, work something through here. So I'm just having a real problem with a black and white decision based on a really gray process to turn around and say this was ex parte. It just seems like it wasn't. It seems like it came from the JLMC side of the matter. And, I think everybody just tried to engage that and, get to some kind of a resolution until they didn't.
Well, I'm not sure I see it the same way, but.
It's okay.
And I don't know what's going on with Mark Terry and them. I have no control of that, no control over what's going on with Flanagan, although I do know even his select board is questioning that. That aside, all I have to deal with is the actions that took place here with Paul and the arbitration. And reading through this, and again, for those of you who've watched these meetings in the past, I did it once several months ago and highlighted, or when the award came out, highlighted my concerns, put it away, and then last night went through it again and saw if I had the same concerns, just to get a fresh sort of look at this. And because it's really each one of us as an island looking at this.
Right.
And I arrived at the same point. And I'm not saying right or wrong. I mean, And in the same way, if we were to do something unknowingly incorrect, we would be filed an open meeting law against us and taken up on charges. Part of it is, you can't be innocent for stuff you don't know, if you still do it. And, as I look at this, the question today is there enough to do an investigation or have a hearing? I think there is. What comes out of that, I don't know. But if you were to just brush this off, I don't think that's right.
I agree. I don't think it's right for either side. I mean, Paul did an extensive 10-page report on everything he feels the way it was. And we got extensive documentation from the hearing officer. So I guess, I don't think you're going to settle anything today without a lot of, you're continuing to do your investigation, you compare notes, and come up with a final decision. I think maybe we're just wasting a little bit of time by arguing about some of this stuff, but that's only my opinion.
From my perspective on that, Ken, is, I just looked at everything that I mentioned before, and then I noticed that the JLMC hadn't done anything with Flanagan with regard to his status on the JLMC, and I went and looked up Mark Terry, because, again, I don't know these people. I looked up Mark Terry. He's currently engaged in, actions right now with JLMC, so I just, why wouldn't JLMC have come down on something? This is my question. I'm not arguing with, what your conclusions are, but why wouldn't they have come down on either side or both with regard to their communications and their actions during this, especially based on this decision? So it's just confusing to me.
No, that part I get, and I think, Paul, you had been in 4 other JLMC.
May I ask?
Yeah.
May I ask a question to Attorney Fair on that note? Is that okay?
Sure. Your hearing, Madam Chair, your meeting.
I wasn't looking for them to come down on Mark Terry or Andrew Flanagan because that wasn't the subject of this case. This case was responding to allegations that were filed against the town of Chelmsford. So my understanding is that there was no charge to the hearing officer during the hearings or at the outcome of the hearings to take action against anyone that was outside of where the complaints were, or to rule on that. Is that, I don't know.
What I was responding to. I was
Okay.
responding to what Ken had mentioned from a document that I'm not aware of. Okay, and that was with regard to black and white requirements about ex parte communication is what I heard. Did I miss that?
Oh, the code that he held up?
Yes.
Okay.
Okay, that's what I was responding to. And my statements stand.
Thank you for clarifying that.
I do find it interesting, and I'm not knocking anybody, because we heard other people Monday night, and there was a show on this where everybody said that they've investigated, printed out the documents, read all the documents and everything else, and, it's referred to as, the code of professional responsibility for arbitrators of labor management. She clearly states it's in there, that's a code they go by, but yet nobody printed out and read it. So I'm not sure how all these people stood up and said they did their homework on Monday night or, on these TV shows, but.
So, wait a minute, so it says the JLMC says that they go by that? Or it says, or she says they should go by that?
She says that's the standard of code.
That's the standard of code, but is that the standard JLMC uses? That's my question.
Yeah.
And it's probably a rhetorical question, because it sounds like the
Yeah, I don't know.
JLMC doesn't use any.
Well, it doesn't sound like that's the convention. That's the way I looked at it.
So I guess I was going to ask, Paul, you've been through 4 of these. Did you write dissenting opinions or talk with the management in other cases like you did here?
I didn't talk to the management in this case.
But did you go back and
Select
forth
board.
between the lawyer and then back to the management?
As I stated in my report, every one of those cases was handled differently, Ken. And that's the part that struck me, was how everything was a unique case depending upon the arbitrator.
Did the hearing officer ask if there was any knowledge, or to Mark Terry or to Andrew Flanagan in the past, had they done these before? Because Andrew Flanagan had done a few of these, and Mark Terry's been around for
I don't know the communication that took place between the neutral hearing officer, the management rep, and Counsel Terry. As you can imagine, in proceedings, whether it be that proceeding or even the hearing, there's communication that take place between those parties that others, including myself, are not made aware of. So I don't know, Ken. I wasn't there. I wasn't part of that. The
Well, what
attorney
I'm
runs
asking-
that.
Right, I'm not asking that part of it. I'm asking you, when you were going through the hearing, it was my understanding that there was the question of if this is common, routine, and it happens from time to time, when? And there was nobody that came forward that said, you know, or neither anybody in the parties or anybody could ever show a time where this had happened previously.
As I said, Ken, every experience I had has been different, which has been limited to 4 cases. That never came up in conversation and was never part of a discussion, because if it had been questionable, then yeah, I would have basically said, hey, wait a minute. The other thing I can tell you is, at the time, while this was taking place, Michael McCall, who's also a JLMC volunteer representative, was my assistant and so forth. He never, was obviously, when I'd hear information and get updates, I'd talk to Michael. Michael never sat there and waved red flags saying, hey, Paul, look, this is going the wrong way. They shouldn't be doing this. So I'm just saying, Ken, it never came up for discussion or consideration. So again, I don't know what's happening in terms of discussions between the neutral and the attorneys, and the neutral and the management rep and the attorneys and so forth. But I can tell you, it never came up in any discussions that I was part of.
And it was never concerned these documents were stamped confidential.
No.
That came up during the testimony,
Right.
Paul,
Right.
that it
Yeah.
was a concern.
It was,
They were stamped confidential.
it was not my concern. He asked me if it was my concern. He didn't ask me, did somebody have a concern, because you've got testimony coming from all parties in the hearing. But no, it was not my concern. Again, the draft award was not shared with me. So if it's stamped confidential, Attorney Terry has it, I don't have it. I believe I read that.
No, I was speaking to Beth Wilson's confidential communications. That was cited during
That was cited
the
during
hearing,
testimony, yes.
that she had marked them confidential.
Right, but again, they're not shared with me.
Yeah, I thought what I read about that was that they felt as though it was confidential to the parties involved, not just confidential to the board, is what I read. I mean, I can't tell you.
Yeah, confidential
beyond
can
that.
can include a lot of people or very few people.
Yeah, I just don't know,
Well,
I would have
actually,
thought
they
that she
did
would have
clarify
put
it.
something out for rules about confidentiality among the board once they went to deliberation. That's what I thought she would have done in writing to make that clear, considering that the process does appear to be, at least conventionally, run a little loose with how they do things with regard to the specific case and the details, et cetera, I guess. I mean, that's all I can tell by reading.
Again, Mark, I
Conventions.
see what you're saying, but I don't see it as that loose. I mean, she even went on to say the JLMC and the neutral, page 28, the JLMC and neutral arbitrator's failure to explicitly inform the parties of ex parte communications are prohibited does not render the conduct lawful. In order to determine the ex parte communications, whether it violates Sections 10A5 and Sections 10A6 of the law, it is necessary to review the totality of conduct, including the timing of the communications, the recipients and substance of the communications, and intent of the parties in sending the communication, and the arbitration panel participants' knowledge of the communications. So
I understand.
Yeah. So
I read
the
it.
way I'm take that as for what she's saying is, some guy gets accused of robbing a bank, and they go out and they get the cameras off the street, and they see a guy walking down the street, puts up his gray hoodie, puts on a mask. Next camera, he takes out a gun. Next camera, he walks in the bank and sticks him up. You're saying, well, we don't know it's that guy, but wait a minute. We have all these other pieces that if you put it together in a timeline, we know it is that guy. That's what she's saying here. You got to take it in the totality of the events.
I'm not saying anything.
But if-
I'm basically referencing what I've read, and I've read what she wrote, and then I also read what Flanagan, in his background, it's limited. It's more limited than Paul's, okay? And then I also read from Mark Terry, and I read Harrington's, basic verbal that he gave to the board. That's all I could read. And it just sounds like that at least half or more of the cases seem to run more open with communication, where they're still trying to find a way to mediate, if you will, or arbitrate before a final decision has to be made. So I'm very confused by a black and white response that Wolfson had versus what I'm hearing the other participants that have been in the system, some of them for 20 years. It's confusing to me.
And if I could just add on that page that you just read from, in between the sentences that you read, it says, presumably there are instances in which communication between parties and committee members may be appropriate, such as communications authorized or at the request of the neutral arbitrator or JLMC necessary to effectuate settlement outside the arbitration proceeding, which is what they were trying to do.
Well, at her behest, but I don't think she said to them, go back and write a dissenting opinion and negotiate all. To me, this went beyond that. To me, that statement says, go out and ask, what's it take to get this to work? How do we get these two groups to sit down again? How do we, not let's hash out the dissenting opinion and come up with a deal here that we're going to work through and we're going to stick in as my own information.
Okay, and so maybe Paul had something to do with the last offer that was made, but he has stated that he had nothing to do with writing the dissenting opinion. And that's what we're here to talk about, whether we should have some future hearing about.
Well, it's not it's the totality of the events and actions.
Well,
Whether he bargained in good faith.
But how can you hold him accountable for what Mark Terry and Andrew Flanagan did? I mean, then you should hold us accountable too.
Well, Pat, I thought the same thing. You were vice chair, I was recused, and I kind of wonder what went on in some of those meetings.
Oh, well, I had nothing to do with writing the dissenting opinion, I can guarantee you that. I've never spoken to Andrew Flanagan. I have no idea who he is. So are you making an accusation?
No,
You're saying
but I want to see, again, Paul references the Harrington thing. I don't know anything about that. I don't, other than what was released in those little blurbs, I think I'd be curious to see what else is there. Because I saw, you remember the night we were in that executive session?
I remember,
Okay.
and you keep bringing that up like you think there's something special and secret
Well,
there.
because I saw reactions.
Well, okay, but I don't think we need to go there.
Okay.
We definitely don't need to go there.
No, this is about whether there is enough here to continue.
I've already made
So
my...
I haven't spoken yet. I think there's a lot to unpack in 10 pages, Paul. I would also like you to acknowledge that there are certain excerpts from the case and the transcripts pulled out of here, but those might not be excerpts in their totality. So, for example, you pull out examples of Jim Clancy's testimony, but not the part where he said that he was surprised that the town was involved in the dissenting opinion, that he did not know that, and that would have affected his decision at town meeting. So, for me, I can't react to 10 pages here today. I would just like a couple points that did come out to me when you were speaking. Yes, the board appoints counsel. The charter designates the town manager as responsible for collective bargaining and for the day-to-day operations in that respect. And so it would not be appropriate under the charter for the board to engage with counsel on collective bargaining, and that is not typically how the town has done that. So, and I don't know what aside from what I heard in the testimony in here, I don't know what that day-to-day communication looked like, but I do know that in my experience, attorneys don't act without the knowledge and concurrence of their clients. So to say that the select board was responsible for Mark Terry, I think personally, I think it's a stretch, because the select board does not have responsibility for collective bargaining, and that is the context in which Mark Terry was acting.
Are you finished with that point?
I let you do 10 pages
Okay, no,
without
I
interruption. I'd like
wasn't trying to interrupt
finish.
you. I was being polite, and I was asking if you were finished
I'm
with
not
every
done.
point. Okay.
So, with respect to Mr. Harrington, I would also like to state that it was his opinion and I have heard this other places, that the hearing officer assigned to this particular case has been doing this a long time and was an absolute expert in her field, and he felt that she would give this a fair process. I know the transcripts have been referenced. I read the full transcript for the first hearing day. There were 8 hearing days in total. The first hearing day was rather short. It was opening statements. I have read number 2 through 8, and I also I sat in person as a observer in all hearings number 2 through 8. I feel that the hearing officer conducted the process in a professional and fair manner. I did not see anything that would cause me to question that hearing process or her knowledge of the JLMC. Talked about that. I know that, like, the other example is there's testimony cited in here from Ms. Wilson and Mr. Driscoll, but there was also testimony that they provided that in their experience on the JLMC, which is broad and deep, that the practice of that went on with Mark Terry and Andrew Flanagan is not something that they would necessarily embrace. So all I'm saying is I think there are things that I appreciate the statement, but to say that this is the statement represented to the community of what happened, it's not in total what happened, in my opinion. And at the end of the day, we're looking at a hearing officer's decision, an experienced hearing officer's decision, a legal decision. And when I take that legal decision at face value, it's not just about the ex parte communications, which I do feel, I cannot believe that we can 100% attribute ex parte communications only to Mark Terry and Andrew Flanagan, because counsel does not act without the knowledge of its client. And the other findings were misleading the finance committee in town meeting when the town submitted a request to fund the arbitration award without disclosure. Counsel was not involved in any of that, and they were not there at town meeting. And then the last finding against the town was in the executive session minutes, which at the end of the day, that was one set of minutes, I believe, that wasn't disclosed. And I also take to heart the footnote on page 34. Which says, in their post-hearing briefs, the town and the union dispute the extent to which the town manager participated in the unlawful conduct or had knowledge of town council's conduct. The SERB has long held that a public employer is responsible for the unlawful actions of its supervisory employees and agents who act within the scope of their apparent authority, whether or not those acts were specifically authorized. Here, the record shows that the town manager knew that town council was communicating with Flanagan, was informed of the contents of those communications, and reviewed the dissent and understood it would be incorporated into the award. In this regard, the town, through its Board of Selectmen, authorized the town manager and town council as representatives for the purpose of collective bargaining, and is responsible for the town manager's conduct as employee and supervisor, and town council's conduct as agent for the employer. So I feel in that statement is also a charge that we have a responsibility. I believe we have a responsibility to do more here than dismiss this as the JLMC being on trial and their process being on trial. There's I mean, I went through it again. You can see my stickies and my underlines if you want, but this was done by a very experienced professional hearing officer, and a very thorough process that included 8 days of testimony. So I have an issue with trying to attribute this to a flaw in the JLMC process or guidelines. And yeah, they've got things they have to work on, but I personally cannot be dismissive of a professional hearing officer and the due diligence that I feel she conducted. I don't think it was done in a nebulous or harried way, so.
May I respond, Madam Chair?
Yeah.
Okay. First of all, what I read and distributed to the board is my statement. I didn't try to attribute it as a town. My name is on it.
But you said the community needs to know.
Yes. The community needs to hear from me.
From you, yes.
and
But
I've done
what I
that.
don't want is for this to be considered the statement to the community about the
Well, I don't think,
town's position.
I don't think
So
that it, I don't think
that was
that it.
my only
I don't
comment.
think that document portrays that.
Mm-hmm.
It doesn't say Town of Chelmsford's position. It says town, it's got my name on the very first line, and it says town managers. Anyway,
That's
so
fine.
I just want to make that clear. The other thing I want to point out to you is, yes, I'm responsible for collective bargaining, but when it gets to the stage of mediation and arbitration, and I'll even add to the DOR hearing, I'm not responsible. I'm not running that. You sat through, as you said, every day of the DOR hearing. That hearing was run by town council on behalf of the town. That was not run by me. Brian Mazur did not, take direction from me on how to conduct that hearing, who to choose for witnesses, all the aspects of that. So all I'm trying to point out to you is the collective bargaining process. Yes, I own it, but when it gets to the legal proceedings of a JLMC mediation or an arbitration hearing in Chelmsford and every other community that I know of and that I've worked in and that I'm aware of, those matters are handled by attorneys, the town's attorneys. That is not collective bargaining. That is formal hearings, not unlike, grievance and arbitration proceedings but anyway,
May I just say one thing?
Right.
I would like to point out that in this ruling, the hearing officer also states more than once that good faith bargaining doesn't end at the entrance to the JLMC process, that it ends when that process is over. So,
Again,
okay.
I'm not here to critique and criticize the hearing officer's decision. What I thought this meeting was about my actions and my behavior and roles and responsibility in this. You cite the misleading of the finance committee and town meeting.
I'm just
That,
reading
no,
what she wrote.
what you wrote, right. But that determination is found from the ex parte communication and the dissent by that Attorney Terry drafted and initiated. She does not find, as I said earlier, that I made statements or any way inappropriately acted at town meeting or at the finance committee proceedings. That is not a finding. What it is it's an implication of the prior thing carries forward into the town meeting.
It goes back to what Ken was citing, that it's in the totality of it all.
Right, but I'm not here to judge the responsibilities of Attorney Terry or Andrew Flanagan. Again, this is about my responsibilities and my role. We're not here to, in fact, you had that discussion not to file an appeal. We've passed that point. I thought today's hearing was to have a discussion about me, about my
Well,
responsibilities.
this is I don't
But
think we've gone off of
But what you're
that.
trying to do is attribute the responsibilities and actions of others involved as flowing to me, and I just don't think that that's appropriate.
But Paul, that's where the disconnect is. We're trying to figure out here is if that flowing involved you more or less. And I believe, from what I'm seeing, is you had a bigger hand in it.
How? What bigger hand did I
Because
have?
they talk about texting, I mean, they didn't, there's no
Were there
phone
any,
calls.
were there any texts between me and Andrew Flanagan? No.
Well, but there were texts between you and the town council, and then the town council and Andrew.
I don't believe there were any texts between me and town council.
Emails, text.
Wasn't there an email that asked, he asked you if it was all right to send the dissent, and was Flanagan going to get paid or something? I don't know what the deal was. It was, he asked you that he was writing the dissenting opinion, it was all right to send it to him.
Right, and I basically said, why isn't Andrew Flanagan writing this thing? And he says, he doesn't have time. I remember it clearly because it was Super Bowl weekend. The Patriots playing Super Bowl that Sunday, and he's calling me and he's saying, well, this thing's coming out on Monday, this has to get done, and do you mind if I draft it? I'm like, fine. And again, as I said, my understanding, he's drafting it based upon the communications he's had with Flanagan, and that Flanagan is going to edit it and put his name to it and do whatever he wants. But I'm not disputing that fact. But I find it hard to believe that you're holding me responsible for an action of a process that's governed by a superior, in this case, the attorney who's holding this, just like I don't think you'd hold me responsible for if there were improprieties during the labor hearing by Attorney Mazur. That just doesn't sound reasonable or logical.
But that's not really ethically right for somebody to write another opinion for somebody else, I would assume.
Well, George, the letter that I received to come to this hearing today, I assume was drafted by Attorney Fair. It had Virginia's signature on it. So is that not ethical and proper?
I'm not getting into.
Because when I look at the verbiage and language of the thing, I said, that's really probably not Virginia's writing style and so forth.
If I may, I don't want to speak for George, but I don't think the question is it not common for attorneys to help draft? Okay, I think the question is more at not the physical act of drafting the dissenting opinion, but the context in which it was drafted. So.
And I agree, and I guess the question is it reasonable for me to have known that wasn't proper?
And to agree, and to allow him to do it.
Exactly, and I have provided an ample document from multiple sources that I don't believe it's reasonable that I should have known that. And in fact, again, let me make this point. If it was so clear-cut and known, that wasn't the opinion of Attorney Terry, who was advising at the time, or Attorney Mazur, who succeeded Attorney Terry. If our case was so ridiculous, why didn't Attorney Terry or Attorney Mazur or recommend to you, stop the proceedings? You're wasting the town's time, money, and effort. Do not proceed with the money, the money and the effort going forward.
I don't know whose
Right, that's what I'm saying.
responsibility it is, Paul. Somebody maybe should have stopped it when they knew it was.
But that's not my
Paul, I'm
responsibility.
going to ask you to let George finish his sentence, please.
No, I mean, but whether it came from Terry or came from you, you ultimately had to be the guy that said, yeah, okay, go ahead and do it, because otherwise you never would have done it, I don't think.
George, the attorneys come back and report to the select board the progress of what's going on, just like in the case.
They never told us anything about that they were writing a dissenting opinion.
Attorney Terry met with the board after the complaints were filed and reviewed the complaints and substance of the complaint. That's in the minutes. And then Attorney Mazur comes on board and is hired and is meeting with the board through the process. It's just like the decision on the appeal was not mine. I will state that basically the board could have put a halt to this. But it wasn't my decision. I don't have that authority to engage and settle and control litigation or legal matters of the town.
Well,
That responsibility is reserved to the select board.
I think the select board would have put a halt to it if they knew that we were writing the dissenting opinion and the guy was going to just cut it and paste it and put it in his, submit it.
Those charges were known to the board because they were filed in the complaint when the complaint was filed. So it's not as though this came to light as a result of the DLR hearing. That was the basis of the complaint that was filed. So the board knew for quite some time of the allegations. And Attorney Terry didn't deny it when he met with the board. He didn't deny writing the dissent and so forth.
I'm not saying he's right.
Right.
But I'm not.
All I'm saying is that I just think
He might not
it's.
have been the only one that was wrong, that's what I'm trying to say.
Right, all I'm just
Paul.
saying is I think it's inappropriate to sort of attribute that to me.
Well, you're-
And I will say this, if a subordinate, if Michael McCall had been handling it, I don't think I would have held him responsible. Because again, this is the person handling the case. It's the attorney. whether it's an arbitration, mediation, or DOR hearing, the command party is the attorney.
I don't know. I don't look at it that way, but it's, you know, I hate to see the people of Chelmsford, I hate to see guys go without money and everything else, when we could have stopped it, maybe taken another direction, maybe get something settled or whatever, I don't know. I just don't feel comfortable with it. I think, and as I said earlier, there's a lot to read what you wrote, there's a lot of things here, and we're not gonna come to a decision, so I think we have to make a motion and go forward, so. But maybe, whatever. I'm only one person.
A motion for what?
A motion to
To continue this discussion or to go to a disciplinary hearing?
do the investigation, if that's what you want to call it, disciplinary hearing, I guess. But, I mean, you have to check facts with facts and whatever, I guess.
Would you mind clarifying the disciplinary hearing, because he's using the terminology investigation? And would you please, just so the board understands what that means?
So typically at the stage of a disciplinary hearing, there's a formulation of what the specific allegations of misconduct or alleged misconduct that are made, that the board feels that, in this case, the board feels that the employee engaged in, the employee would be given notice of the scheduling of a hearing in some advance, time, because there is sometimes some preparation necessary, but the board would need to decide what exactly you're holding the hearing on, like what the basis for the charges would be, as opposed to an investigation, which is more of similar to what we're doing here, which is we're sort of exploring, what information's out there, whether or not it rises to the level of necessitating actual disciplinary charges. I'm not sure. Hopefully that distinguished between the two, Madam Chair?
Yeah, I'm just trying to understand the terminology that's being used. I wanted the board to understand the difference. So investigation would mean we continue this discussion, we take time to look further and continue this discussion. Disciplinary hearing would mean we come back together to discuss discipline and the rationale behind that. And the third option is do nothing.
Correct.
Those are basically the three options ahead of the board right now.
Right, and with the disciplinary component or that option, there would really need to be some identification of what exactly, we're alleging as far as the misconduct. So you'd really kind of need to crystallize a little bit further for purposes of providing the employee with notice of what he's actually being charged with, so to speak.
Comments?
I would think that the charges is what's basically made in the hearing brief, is that did he negotiate or bargain in good faith?
That's why we're here. Should I go around the table?
I agree with it. I mean, that's what it's about.
And after reading this, I'm not sure he did, so.
He did what?
I'm not sure he did bargain in good faith. I think there was stuff going on back and forth, and is there proof? No, but, I mean, there's, as stated throughout the brief, there's, a lot of back and forth between Paul and the town council and the town manager Randover. When the town council emails Flanagan and say, best case, can we do 1% here and 3% there? I don't know where he comes up with those numbers without talking to Paul. And I agree with you. I've dealt with attorneys, we've dealt with them here, they give you your options. Here's option 1, 2, 3. This one has no risk, this one has a lot of risk, and this one is a walk down the middle. Which one do you want to do? I think that was spelled out.
Anyone else?
I think you did negotiate in good faith, and I think you, with what you just said, as far as Mark Terry knowing numbers to present, prove that. That's just my opinion.
For me, the irony here is it seems like everybody is saying, yeah, we did talk. Nobody's trying to say we didn't talk. We did talk. We were contacted, we negotiated. Paul has said he talked to Terry, Terry talked to Flanagan, back and forth. There's the irony here for me is that there's no dismissive, opinions about, oh, I didn't talk to them. Everything's being acknowledged. The real question is that really illegal? I mean, I read the opinion, and then I also read the other opinions from the other attorneys that have been involved in this process, and I have to be honest with you, I'm completely confused by it, and I'm not sure how I go to a disciplinary hearing and make some kind of a determination based on what sounds really confusing to me. I mean, it almost sounds like attorneys don't know how to land on this in black and white. I realize there's a ruling, but that's one ruling, that's one attorney. So I'm just not sure really what to do with this personally.
What other attorneys, so you said, this attorney and other attorneys, it makes it,
Yep. Flanagan Harrington, from what I read.
yeah.
Mazur, from what I read, based on his experience. Mark Terry, from what I read, based on his experience. So, I mean, that's all I have to go by, Ken. I don't have any long history with JLMC either.
Right.
Neither
In
do
the
you.
same way, Mark, sitting in
Yeah,
there, if we misstep and we do something wrong, we're responsible.
Yeah, to some extent, you're absolutely right. But there's a difference between personally being responsible and being responsible as a board in the town, I believe. So it's different.
Well, if I come into one of these meetings and I have an ethics violation filed against me and it goes up to the state level, I personally write the check out for 10 grand.
Right.
I'm personally
And I
responsible.
would think that if Flanagan or Terry acted inappropriately, that somebody would have done something with them too.
Well, it's also,
That's what I believe.
but it's also early. I mean, this decision came out, 3 weeks ago?
Well, I'm just
I know
saying,
Andover's discussing it.
that's fine. I mean, and they should.
And I will say before we go any further, Pat, I want to apologize for that comment I made earlier. I'm not assuming anything was done out of context or anything else. What you heard from me was my frustration and anger that we're even here, in that we're in this situation. And it puts us all in a tough situation, so when I said what I said, I apologize for that. I don't think there was any misgoings on or misdeals or anything like that, so I just want you to know I apologize.
And I'll just add, I'm not saying I'm infallible, that if I had to do things over again, I wouldn't do them differently. But I think I just don't think it's reasonable to warrant a disciplinary hearing against me based upon what this board knows from the decision and what you've known for quite some time throughout the testimony and hearings and updates from counsel and so forth. So I think that's the question. As I said, I won't dispute. It's undisputed that I was in communication with Attorney Terry. That's indisputable. The question becomes does the totality of the actions warrant the board to take a disciplinary action against me? And I think clearly, if you know my opinion on that, no way. And as I said, if I was if this was being done by a subordinate of mine, I wouldn't take action against a subordinate of mine. So that's the decision the board has to make. We're not here trying to judge the hearing officer's merits or decision and so forth. It's a question of what everybody knows and has seen over this painstakingly long process. Does this warrant a disciplinary hearing for the manager? And you clearly know that my point is no.
Yeah, but Paul, so, I mean, you just said it like you would have done things differently.
Yeah.
There
Exactly,
are
had
codes-
I known.
Yeah, there are codes of conduct that should have been followed, so you just answered it. Yeah, there should probably be a disciplinary hearing, but who knows what the result is? Maybe it's a slap on the wrist, maybe it's, I don't know, but I think it is warranted to have a disciplinary hearing because things were done incorrectly, and I can't hold Terry and Andrew Flanagan.
Right.
But I only can answer to what you did, and in the case here, yeah, you even said it, you would have done things differently. And I think they should have been handled differently. So
But
that, to me, justifies a disciplinary hearing.
But
was it reasonable for me to have known? And then this code is not on the JLMC website, so to sit here and say, hey, there's this code of our.
Well, it's only here because she cites it as a
Right,
code.
exactly. So again, how would I be aware of the code, is my point. It just seems like you're grabbing onto things and then transferring them to me. And I just don't think that's reasonable. To sit here and
Yeah,
say,
this
hey,
is
there's
all I
this
have to go
code.
by.
There's this code because of a footnote in the thing, therefore the manager should have known this. Well, again,
Well, Terry,
that's what the attorney's there for.
well, Terry should have known it, correct?
I don't know, George.
Well, I mean, if he appeared so many times in front of them, should know the code, I would assume.
Right, but
And
he.
if he did something wrong, maybe do we have any legal recourse against him? Mr. Fair?
And if that's the case, I just look at it and say, why doesn't the JMC make them read that and sign off before they get started? You know, I'm not trying to say no to a hearing or anything else or anything further, but those are the questions that bounce around in my head constantly.
And just one point I'd
It's
like
like
to
if you
make.
can fog a mirror and you've got a little bit of background, you can be on the JLMC, and that doesn't make any sense to me.
At the end of this decision, it does say what the order to the town is, cease and desist from doing these 4 things. So, I mean, that to me is disciplining, and I think that's the level of the discipline that we should all take to heart.
Well, you're right, and item number 1 is stop
Right, stop doing that, so,
failing to negotiate, bargain in good faith.
well,
So, you're right, she's saying you
but.
stop
yeah.
doing this, which it's
But
not in
the-
good faith.
But it's defining not in good faith by something that we didn't know was illegal to begin with.
Because you don't know it's not illegal doesn't make it
I
okay.
understand.
And this is how things get changed. You know, court cases happen for reasons.
Okay, so maybe the JLMC will also take this to heart.
Maybe they will.
We can only hope.
But I only can answer to the townspeople for the behavior that took place.
But if that was the only thing that's really at stake here, is that something we should be applying in a disciplinary hearing at this point? That's what I have a question about. It's that much of a reach where they've got to really decide whether they adopt that or not. That's where I'm just so confused with this.
I don't think it's a reach, Mark. She specifically says, stop bargaining not in good faith.
Okay, so, and maybe that's directed toward the town council, too. I mean, and we have a new town council.
Yeah, I don't know.
I don't know what you just said. I couldn't hear it, Pat.
Just that, I think if you look at this, at this hearing decision in totality, it's town council that comes out looking the worst, and that failure to bargain in good faith, I think, could be directed at town council. And we have made efforts to rectify that, in my mind.
I guess I'm a little surprised at the statement that if my employee was found to have broken the law, I would do nothing. That just is not, in my experience having employees, you'd at least get a letter in your file or something, Paul. I'm just surprised by that as a rationale.
No, Virginia,
And I-
oh, go ahead. Sorry, I thought you were.
I go back, mostly, I go through the whole thing, but I go back mostly to page 2 and page 34. Okay, where the explicit violations of the law are stated, where they don't all involve town council, where it's taken in its totality, and where we have a responsibility to address this. I think we have a responsibility per our select board policies, where the manager is accountable to the board. And I have a real concern with ending the conversation today because we don't like the JLMC process. And frankly, that's what I'm hearing, that we have a process that may be nebulous, or the practices or how they bring people on board. I mean, it says in here the governor appoints them. I just have a problem ending the conversation today based on confusion about how the JLMC conducts their business. I think there's a lot more to it than that. And I think that, as I said, we can all pull out excerpts of transcripts, and they're not all going to be the same. And so I do think this at least warrants a further discussion if people feel they need more time to do their homework.
I don't think anybody needs more time to do their homework as much as I think we need some help in guidance with how to interpret all this. That's what I think. And to find out, given the situation and the circumstances, is this something that in fact the town manager should have understood, and once he got involved in certain portions, whether it's with the ex parte communication or others, should he have not done that? Is that clear? That's what I need. So I think if we just sit there and keep reading, and we're going to just keep going back and forth with these differing, opinions and so forth, as opposed to getting a little bit of help with this. I don't know how I can move to discipline somebody when it's not clear to me, what's really the responsibility of the town manager versus the attorney versus the GLMC process. It's confusing.
Madam Chair, if I may, I think you distorted my statement. What I said, I didn't say that if a town employee broke the law, I'd do nothing about it. What I said was, in this circumstance, had it been an employee subordinate to me, for example, as the board is aware, when Michael McCall was my assistant town manager, he did all the bargaining process, collective bargaining and union work for the town. All I was implying was that if Michael had been handling this, or somebody like, in these circumstances, I would not have taken any action against that person. I did not say that I wouldn't take any action against an employee who broke the law. I said, based on what's transpired here and the information and circumstances in this case, I would not take any action.
Thank you for clarifying that.
Thank you. The other point I'll point out to Select Board Member Corrado, because he was not here, and I know members of the board were here, when the board sought legal guidance, after the charges were filed about the behavior during the arbitration proceeding, and they brought in town council Paul Haverty. And as the board's aware, Paul Haverty had a very extremely difficult time finding an attorney to advise the board in that process.
No, I read that.
And the reason for that is because they don't want to get involved. Because many of them don't want to jeopardize their role in activity before the JLMC, because
Right.
and the same thing happened with the hearing officer, as was noted in the thing. The arbitration hearing officer had to be subpoenaed to testify in this DOR hearing because of her concerns about being a neutral arbitrator, because of the nature of that. So all I'm saying is it may be challenging to find somebody to provide that guidance to the board. And again, I would just hope by now it's pretty clear, based upon the testimony of individuals involved through this hearing, that that it isn't black and white. And so I think the only thing you're going to find going forward is more gray. And again, I guess I'm not faulting the board for having this type of a meeting with me. All I'm saying is does it warrant going to a disciplinary hearing? And I've already expressed my thoughts on that.
Just so you know, I did read the minutes back then about finding an independent, and I do know they had a hard time. The rest you said may be speculation, because that wasn't written, but I just know that they did have a hard time getting somebody to do an independent assessment.
But I still don't buy that. If everybody's doing something wrong, that makes it right. Right? I mean, if everybody's out there doing this, and so nobody will show up and testify about it, that doesn't make it right.
and around we go.
Yeah.
Right.
This is circular, this is the problem.
So I think the next step, right, is if we sit here and say, you know, I do find reason for disciplinary hearing because I feel the town did engage in ex parte communications with the JLMC member, drafting a dissenting opinion that it was incorporated in the arbitration, and misleading the finance committee, well, then we go to the next step, where we have the hearing and figure out what are we going to do about it.
Is that a motion?
I can't, I mean, I can't argue against the statement that the town violated the law. I don't have the expertise to say that's not true.
I don't either.
Okay.
Again, this isn't, I don't think.
Excuse me.
Okay.
Can I just stop her?
You may. Thank you.
I just feel it's important to sort of clarify a couple things. When these charges get filed, they get filed against the town, right? And under 150E, technically speaking, the town is defined as the select board, but in effect, it's the town of Chelmsford. And the decision makes clear that you're responsible for the acts of agents that you've empowered to essentially act on your behalf. So the conclusion in the end, or a finding that the town violated the law, is clearly on its face. What I think is the board's difficult task and what you're sort of wrestling with is, to what level do you ascribe that finding to actions or inactions of the town manager? Because other individuals are involved in this proceeding, engage in certain acts, and can nonetheless still result in the town being found to be in violation of 10A5 or 10A1 that could be completely independent of the town manager. So that's part of the difficult task I think the board members are wrestling with, is how much of what transpired do you attribute to the town manager as to what he should or should not have done, or what he should or should not have known about what was happening. And the reason why I raise that is because if you are moving forward with a disciplinary process, I think in fairness to the town manager, we would need to be, I guess, a little bit more particular as to what it is that we're saying the issues are with what he did or didn't do, as opposed to just, you know, there's a finding that the town didn't engage in good faith bargaining. Because as I read this, it really covers a bunch of individuals, and we would need to be a little bit more particular. The other point of clarification, because it's come up a few times, and I just think it's important for to place it in context. You know, this notion of the codes of professional responsibility for arbitrators. The documents that are being cited in the DLR's decision are, one is the Code of Professional Responsibility, but that's from the Federal Mediation and Conciliation Service, which is essentially, you know, a federal agency, and what they expect their arbitrators, and the code they expect that arbitrators that they are utilizing or that are on their arbitration lists will follow. They're also citing to the AAA, National Academy of Arbitrators, American Arbitration Association, again, talking about what an arbitrator is supposed to do. The difficulty, again, for the board here is that the arbitrator, the true arbitrator as a profession, is Beth Wolfson. She certainly would be aware of what those are and would be following those, and she handles other arbitrations, not just JLMC arbitrations, grievance arbitrations, and things of that nature. The other members of the panel in this case are a labor representative and a management representative that, as you noted, get appointed by the governor. They sit on the JLMC, but they're not labor arbitrators. They are, in the case of usually on the management side, they're, you know, town managers, or they could be police chiefs, fire chiefs, retired or otherwise. And on the union side of things, they're union presidents from other locals, or union officials, or it could be a statewide union official. So those folks they're not arbitrators, so they're not necessarily following that code. Now, to what extent the JLMC educates them or provides them with this information, that I can't speak to. But I just wanted to sort of distinguish between, there is a neutral arbitrator, professional arbitrator, let's call her, in the form of Beth Wilson, and the other panel members are not arbitrators at all. They're on this JLMC panel. They're part of the arbitration panel within the meaning of the JLMC, but they don't arbitrate cases outside of the JLMC process in most cases. I can't say all exclusively. There may be some members, but by and large, that's not what they're doing. They're in cities and towns, or they're retired folks from municipal government. On the management side, and on the union side, they're union officials.
Thank you. Mark, may I go back to a comment you made?
Yeah.
What would help look like?
What would what
Help look like?
help look like? Well, actually, what Attorney Fair just pointed out was very helpful, because in my mind now, the document that Ken referenced is certainly valid as a reference material for Beth Ann Wolfson's response, but it's not something that even the tripartite labor and management rep may or may not be aware of, may not be come versed in that. That's what I'm having trouble with. So what would help be, I guess, to take that further, to understand, should the town manager have known what that process says? Should Mark Terry know what that standard is? And should Flanagan have been educated in that standard? Because I think in the minutes it says no one's educated in it. He attended a meeting in Chatham, had a couple of things he sat on in Leominster or wherever else, and then suddenly he was sitting on panels. So that would be helpful, to know whether that's a real standard that everyone should have been aware of, and they should be responsible to that, because if they were, then I could understand potentially why disciplinary action might be warranted. So that's kind of where I'm at.
Okay.
Thank you, Attorney Fair, that helped.
I don't know where you want to go with this today, other than the fact that, I clearly think there is some liability to Paul. It's not like there's zero liability, and that, whatever we measure that out is what comes out in the hearing, and that justifies whatever, if any, punishment gets doled out.
Yeah, just so you know, I'm not arguing for or against what you're proposing. I'm just trying to understand the facts and the reasons to go there.
So I'm not sure, you would have said that you have to be a little bit more clear. That's the guidance, I think.
Well, I think through you, Madam Chair, what I was really referring to is I think the board would need to be a little bit more specific about what actions or inactions of the town manager are specifically, at issue here. I think to just simply cite to the conclusion of the DLR that the town bargained in bad faith is overgeneralizing, because the town is responsible for all of its actors, and not just, and some of which are not the town manager. So you have to sort of distinguish or determine, I suppose, which actions you think the town manager either should or should not should or should not be held, responsible for. Those that are sort of outside of anything that you might think is something he should have known or done. Obviously, we exclude those. Things that you think, he should have done differently, or actions that he should have taken but he didn't, or actions that he took but shouldn't have, those are the things that you would really need to kind of identify, as opposed to just citing in general the town bargained in bad faith, and we think that the manager's responsible. Because just from notice, an opportunity to be heard standpoint, we need to kind of define what it is he's to defend himself against relative to charges,
And
disciplinary charges.
would we discuss the definition of those potential actions or inactions in a continuation of this complaint meeting? Or in a disciplinary hearing? That's what I don't understand.
Sure.
Yeah, me too.
Let me clarify that. You can't, part of the process for holding the disciplinary hearing is we have to send the town manager, notwithstanding what he's opted to do and hold this in open session, you're always going to default to a notice of executive session as the employer, as the municipal board. That's just what we would always recommend for employee privacy reasons, because it's his option to have it in open session. So you would default to a notice of executive session. You have to provide it to him 48 hours in writing in advance of whatever the meeting is scheduled for. And for due process reasons, you would need, if he's going to be potentially disciplined, identify in that notice what it is he's being accused of. You can't send that notice, really, based on the discussion. Obviously, every case is a little bit different. If the allegation was clear-cut that town manager did X and it was not really debatable as to it's whether or not he did or did not do a certain act, that's not what we have here. The board is wrestling with what exactly we think the manager should or should not have done. I think you need to identify what those look like, what those are, those subject matters, before you can send out a notice of hearing.
So my question is if...
You would
if
do
the
that in
board-
this process.
Right, so what we would do is continue this complaint discussion and come back again with more specifics that we talk about as a board to determine whether we take those specifics to a disciplinary hearing.
Correct, because I'm not hearing...
Because I don't think we're going to get that level of detail this afternoon.
Right, and I'm not
This
hearing...
is the first time we've talked
Certainly.
about it.
Right, I don't think you, at this stage of things, have, as a board, I don't know that there's a majority that is really kind of crystallized around, well, what exactly should or should not have the town manager have done? What are we holding? What do we think maybe he should be held accountable for himself personally? So if the board is in need of more time to review that, then yes, that would be more or less a continuation of this process before you then would be in a position to put pen to paper and send him off a notice of executive session for a disciplinary hearing, in my view.
Okay.
I mean, I don't know, I really, if we can get this done today, because we tend to go through these meetings at last hours, and
I don't know that, if, are people prepared to do that today? That's my,
I'm not.
I think we can schedule the next discussion today if that's where the board wants to go.
Yep, that's fine with me.
Ken, what would you lay out as your specifics right now?
I think specifically, the town manager was involved in ex parte communications. In knowing that through the being in possession or receiving confidential documents, and I think town meeting was misled.
Can I toss something out on that? Should we also, within that, reference the JLMC rules of 79, this and that document there too, to find out if he should also have been aware of those requirements, which led maybe to an impropriety where he,
I don't know, is that how you write it?
is that what you were referring to? That's how I was taking it.
I'm not sure I followed that, Mr. Corrado.
Okay, well, I was saying is, the bottom line is, are we going to try to find out whether or not the town manager was responsible for understanding, interpreting in his actions according to the JLMC rules, which were adopted, and the standard that Neutral Operator Wolfson references in her decision, because that's the basis for his involvement in the ex parte communication, right? Whether it's right or it's wrong, it's really based on those standards.
So there's, and maybe there's a little bit of a chicken or the egg kind of approach
Okay.
here, but there's, in terms of coming up with charges, right, it's identifying whatever it is that you think the charges are, and what he should be held accountable for. To some extent, you could make a decision on what the charges are, and then really would be up to the board to demonstrate through some sort of evidence or information that, in fact, we think the town manager should have known about these standards, et cetera, and you're basically proving your case, so to speak, at the disciplinary hearing itself. Alternatively, you could pursue that information in advance, almost as if you're doing your own investigation, which often happens in these cases, no different than if, you do a disciplinary, here you have an allegation, somebody does an investigation, you figure out really the fuller set of facts that you want to know, that you're interested in finding out, and then you make a decision as to whether or not to have a disciplinary hearing. It really depends on what order you want to do
I
those.
thought that's actually what you were recommending from what Virginia had mentioned,
Well,
because it didn't seem like we were ready for a more specific charge until we understood some of those other facts.
so that becomes, I guess, a matter of individual perspective,
Okay.
right? It's if an individual member feels that they have enough information now to identify a particular charge, that may be their own personal view. I'm hearing, not to put words in your mouth, but I'm hearing you as saying you don't feel like you have that information, so you would be more in the camp of looking for more information before you can make a determination of whether you want to whether there should be charges, right? Gathering information
I
first.
look at it as I'd rather already know, and then know what the charge is going to be, and then there's no discussion, it's just a discussion about what the discipline should be or not. That's just where I land on that, but I'm okay with other, whatever everybody thinks, but.
I agree with what Ken said, to be honest. I feel that that's what road we should be looking at.
If that's where you want to go from today, then we need to spend the time to articulate that for the notice. Either that, or we pick a date and say we're coming back to continue this and to just get that crystallized. Yeah, go ahead, Joe.
So just for purposes of clarification, I know this is kind of been going around on this. When you articulate whatever it is you're going to articulate for charges, I think what the board just needs to remember is that when you get to the next step, we're going to need to present information to support those charges. And to Mr. Carrada's point, again, he's expressing a process of, let's find out the information first, figure out what the charges are, and then once we have all the information, obviously the town manager will have an opportunity to respond to that, but the board's position will be more crystallized. If you feel like you have enough with what's in here or what's already been expressed, by the hearing officer in the references to the transcript, et cetera, I didn't sit through those, I didn't read all the transcripts, that hasn't, not been a task to me. That could be someone's position and they feel like they know everything they need to know as of today, and I'm not making a judgment on that, but I just want to make sure the board understands that if there are pieces that are still sort of vague or unknown, then Mr. Carrada's point is that you would sort of figure that out first, so you know what exactly it is, the town manager did or didn't do that he should be held accountable for.
Thank you.
Go around the board recommendations.
Well, I'm not ready today to go through and look at detail about what ex parte communications you're referring to, Ken. I would like to, like what Joe just said, kind of reference some of the transcripts and other sightings, both in Paul's statement that he made and others that I didn't go through every citation that was mentioned in the decision, and I would like to do that. So I'm not ready to go further on this today.
May I make a request?
Sure.
If board members are going to go look at the transcripts, I ask that you look at them in their totality and not at selected excerpts.
And there's how many hours of them?
Well,
I know,
we've
I'm
had
just
them for how long?
I know.
Are you going to read you're going to go through the testimonies?
I'm sorry, Mr. Dixon.
Are you going to read the testimonies?
I have not been asked to,
Well, I'm asking
Well,
you
that's
if
what
you're
I'm-
going to do, I mean,
Thank you, George. I was going to mention the same thing.
so it's a question of whether or not, I mean, if the board is looking for my review of the evidence and the decision, et cetera, I mean, I can certainly provide that, but that's not been asked of me, so it's not something that, the purpose of today was to discuss what the board wanted to do in response to this, if anything. So if that's the pleasure of the board, I can review everything and review the evidence and give an assessment of what I
well, you
think.
can always
but-
review it anyway, and you'll have it in your head, so if somebody brings something up, you'll understand what they're referring to.
Again, we operate at the direction of the board, so whatever the board's pleasure is,
I'd
that's
appreciate
what
it
we
if
would do.
If you read it,
I just don't want to be undertaking, I mean, there is a lot to review, so just so everybody understands, there's a lot to review. It would obviously take, a fair amount of time to do so. So
Yeah.
I just want people to be prepared for that. So I don't want to undertake that exercise without making sure that the board, I guess, as a whole,
It's ready for the hours it's going to take.
yes, and the expense.
well, I mean, I think it makes it a lot easier if you're very familiar with everything, and to make a, decision that's fair to everybody, you know what I mean? Or what you think is proper, if you're asked. I mean, it's hard for me to ask you a question about something you don't have all the information about. In my opinion,
Okay, so the question on the table is, does the board want Attorney Fair to review the transcripts? And to what end?
I mean, I did take the time and did the homework and went through and did all this, so, I mean, I'm ready, I don't,
Yeah, but that's not the question.
no, I know, I just, I can only imagine that, how many days of testimony, 8 days? And how many hours each day?
Several.
It's, 56 hours of,
I do want to say, if I may, I did read the decision, so I have read that much. So I don't want anybody to think that I came completely unprepared here. But, reading all the transcripts and all that would not be something we would undertake on our own.
Well, is that something where you could do an interpretation of the decision based on the sightings and so forth with regard to the town manager's responsibilities to it? Without reading?
So I can certainly render an opinion to the board of, the decision and the information that's in here and the factual findings. So in essence, deferring to the factual findings because that, typically if this was being reviewed on an appeal level, oftentimes the hearing officer's findings of facts, unless there's just no support for them in the record, are deferred to. So, I mean, I certainly could review this from the standpoint of assuming the factual findings are correct as expressed in the award, and then rendering an opinion based on those factual findings as to,
Where the responsibilities lie.
right.
That's
And I-
what we need to know.
I think we were told, yeah, it was in our minutes that just got released. We were told by Attorney Mazer, you mentioned even the word appeal, but if those things are appealed, the state typically defers to what the hearing officer said. So are you asking him to validate what the hearing officer
No,
said?
I didn't ask that at all. I
Okay.
asked for where does the responsibility lie for what was the judgment? So there's a judgment here, the citations all over it, and so based on that, where does the responsibility lie for the ex parte communication? How far down does it go? Where does it, lie for, not giving out executive minutes, for not, responding to this?
Isn't that our
Where does
job?
it go? Huh?
Isn't that our job?
I think so.
I don't think so, Ken. I think I personally feel like we could use, someone else's help on how far that goes. He already said that there's a standard that you have that Wolfson cites that isn't necessarily adopted by the JLMC. So, I mean, that's a question for me right now. I'm not an attorney, and I don't have any experience in this. And I would appreciate having some knowledge before I could vote on any kind of discipline for anybody. Whether it's, whether I think Flanagan did it, I hope Andover's looking at that. Whether Terry should have done something different, I mean, I just would want to know that.
Well, as of September 13th, they are.
I don't care.
Well,
I just
you
wanted to know.
wanted to know.
But we're sitting here right now, and we're talking about that guy right over there. And I just want to get some advice on it.
Okay.
Because if from a legal opinion, they feel as though that based on the charter and the way that the requirements that you've referenced, or that Beth Ann Wolfson referenced, are applicable and they fall right through to Flanagan, Mark Terry, and the town manager, I want to know that. Because then I know what to do about discipline. Otherwise, I'm not sure I do.
Having read her decisions, you feel that's enough? I mean, you're an experience, you're experienced in this field,
Well, I just want to clarify some. So what the chair mentioned about a statement made by Attorney Mazer about if it was appealed, they would defer. I just want to distinguish between, they typically will defer primarily to the hearing officer on factual determinations. So if there's disputes of fact and you have to make credibility determinations, they often will defer to the person who is in the room hearing the live testimony. Sure. The legal issues are always open for review in any situation. So the legal conclusions or how those facts are applied to the law is something that would still be open to review on an appeal. So I don't think that's what Attorney Mazer was referring to. He's just saying they're going to defer to what the hearing officer found. So if you feel like, well, this isn't really how the testimony came in, I think it was, she's taking it out of context or something to that effect, he's right. Chances are you're not going to really win that. They're going to be deferential to who found the facts at the time, unless it's really not supported at any, they come up with a factual finding that has no basis in the record. So, in that regard, the factual findings are here. You have stipulations of fact and you have additional findings. And then from there, she makes conclusions on the legality as it relates to the town, but not specifically to the town manager. And that's really why we're here today, is how much of that is ascribable to
Right.
the town manager.
That's all I want to know.
And whether that's me or somebody
it's-
else, you could bring somebody in from the outside to do a review of this, if you prefer to handle it that way. It's not,
So my take on all that is, well, if Paul's hands are totally clean, there's no discipline. But if you feel he had some, even small, then there should be some discipline for that.
No one's disputing that. I'm not, at least. I'm not disputing that with you at all.
So I'm just trying to figure out where we're going today, because we've been here 2 hours, like, what are we doing?
Yep, me too. I think we're trying to come up with some specifics, either a specific complaint that we want to go to discipline on, as Attorney Fair pointed out, or do we need to get a little bit more information before we know how to go there? And whatever you guys. I've been clear, I think.
I think I have too.
With respect to the ex parte communications, in this ruling, it does say that the town manager was aware, correct? The code or not aside, I guess I think what it comes down to is whether the board feels that was appropriate,
Unfair.
right? So,
I've already
I
stated
just
my
don't-
opinion, so. I've stated my opinion on this, I'm not gonna go any further. I think I would like to get,
so if we were to move to a disciplinary hearing, Mark, you would probably not, you would not
I don't
support
think I'd
that.
have enough information to decide what level, if any, discipline should be applied to the town manager based on the standards of conduct that are referenced. I'm just not sure,
Right.
period. I don't know what else to say.
And I guess what I'm concerned about is if we go from here to a disciplinary hearing, and that's where at least one board member's head is at, it's the productivity of that discussion and the ability to come to conclusion, I think is going to be left hanging.
I do too. I do too.
I mean, I'm comfortable in the top 3-level things, Ken, that you pointed out. I am not at all comfortable ending the discussion today. I've said that, and I'll say it again. I think there has to be another discussion, and it's just whether it's a continuation of this.
So go ahead and schedule it a continuation, and we'll get back together.
You said you wanted to or you didn't want to? You wanted to end?
I don't want to end the discussion today.
In other words,
You want to end it today, you just don't want to end the discussion.
Are we able to talk about schedule now,
Yep.
so that we don't have to drag this out?
I will be here. You just tell us the time.
How much time do you need, Joe?
I guess it would depend on what exactly I'm being asked to do. If I'm being,
I mean, frankly, I'm concerned about over-exercising you,
Yeah,
because
all right.
there's, like, only so many legal documents we're going to produce here, so I think we have to be very specific on what we're asking for.
I think he's comfortable.
Can you help
Can I help
clarify
a little
that?
bit?
Yes.
You know, for me, it's first off, the judgment as was laid out by Beth Ann Wolfson. All of the rationale and references that she laid out in her findings to find out to what extent the responsibility lies with the town manager in those citations. That's kind of what I need to know.
And just if
Is
I
that-
can, Mr. Crowder, just for clarification.
Yeah, sure.
So Beth Ann Wolfson was
She's not the-
she issued the
No,
JLMC award. You mean the DLR
I
hearing
do, I meant
officer?
to, yes.
Sarah's
Okay,
the-
Sarah
Exactly,
Hiller,
I'm sorry.
okay. I just want to make sure.
Yeah, no.
That's what I
Well,
thought you
and-
meant, but
Yeah, I
was-
did,
And
I'm sorry,
gonna
there's too
add
many
to-
names.
I'd like to just add to that, okay? I don't want you to feel like you have to tell the board what the outcome is.
He won't.
And that's what I get concerned about.
I don't think he will.
But, right, but I'd also like to know where it's a judgment call.
Yeah,
If
me
you think
too.
it's a judgment call.
Me too.
Because I
I-
think some of this is a judgment call, and frankly, I'm prepared to make the judgment call, but if the whole board can't get behind the meeting, then let's get through it quickly. So,
we would be, for purposes of clarification, that what we're scheduling is just a continuation of this discussion.
yes.
And so-
Informed by whatever you produce for us.
And are you looking for me to send the board something in advance of the
I
meeting?
would.
Okay. Today's the 29th. What does the board's schedule look like for coming back here? I can get something to you next week,
Okay,
and then we'd come back here the week after that. For me, right now, it looks like
next week, meaning like
so
not before the end of the week, or,
So the week of the 10th is coming back?
well, I was even looking like a week from now, but,
Oh,
what I guess I was saying was I would be getting you something in writing next week,
yeah.
a summary of some type. And then we would be meeting back here the following week so that you have time to consider, review, ask questions. There's certainly nothing, as long as the board's not discussing amongst themselves, if a board member has questions about whatever it is, about any of this, they wish to ask of me off, independent of any conversation with others, that's permissible within the open meeting law. So you could certainly do that, and that gives board members time to ask those questions if need be. So looking at the week of...
and then we come back with what we want. If we feel that we want a disciplinary hearing, we come back with the specifics of what goes into that.
We would meet back here to have a discussion
meeting.
to identify, what the disciplinary
I'm just
charges would be.
Saying the board has homework before that meeting.
That's right. Based on whatever information you have presently and any additional information I provide, the board would need to show up at that next meeting prepared to say, here's what we think we should be doing next. Either nothing or scheduling a disciplinary hearing for these specific issues.
Right.
So the week of the 10th, so Columbus Day is, so that's a holiday. I could do the 12th. Depending on timing, I can do the 12th. I have a night meeting, but
Yeah, Paul has a pre-info meeting that night.
What?
Paul has a pre-info meeting that night.
He said he has a night meeting.
Yeah, he
No, I
could do
know,
the
but I'm also
day.
saying we can't do night because of you,
I
too.
thought he was thinking the day. I thought he was...
Oh, okay.
that's what I'm saying. I can do the day, I
Can we
just
do
can't
during
do the night.
Can we do during the day on the 10th?
On the 12th, you mean?
The 12th?
10th is all.
I have an appointment at 1, and I would have to leave here by 12 to get there.
Okay.
The
So
13th
we
is
could
wide
do, we
open.
could do the morning.
I can
We
do,
could, but I'll just have a hard stop, that's all, 12.
yeah, and I'll start as early as anybody wishes.
Oh, that's fine.
So,
9?
9 is fine with me.
Sorry for the drive, Joe.
no apology needed. This is
That's Wednesday, the 12th?
not the furthest I have to drive, so.
Wednesday, the 12th at 9. Paul, does that work for you?
Yes, that's fine.
Do we have to provide Paul another notice, or we just know that it's a continuation?
I'm a week.
I'm just asking. I
It,
don't want to make a mistake.
no, for purpose, I mean, we can, it wouldn't be much for us to just change dates on a letter and send it to him, and then he, again, so. I would err on the side of caution myself, anyway, and
No,
not
that's
because of the individual, but that's just how my normal practice would be.
Okay.
You don't leave it to chance.
So Wednesday, the 12th at 9.
And so are we just motioning to
And-
end the meeting or to continue?
I would motion to continue it.
Yeah, I mean, it's not a hearing per se, so it's just we're having another meeting. There's no particular formality of, it's not like a public
So do I
hearing.
just make a
Wait,
motion to
Can we
adjourn?
motion to adjourn to the 12th?
Sure, you could do that, but one thing I want to make, just to make sure I understand what I'm being asked to do, is to review the decision. I'll defer to the hearing officer's factual findings, and you would like an opinion as to what specifically? I know you want me to leave it to your judgment as to what you do, but am I guess, critiquing the legal findings? Is that what I'm being asked to do, or?
I'm uncomfortable asking you to critique
Yeah,
a
I'm
set of
not-
No, I think I'm-
I
Okay.
was looking for either.
I would
Okay.
ask you to define what, based upon what's in that brief, what the charges would be, and then we have a discussion whether they're valid or not.
Well, mine would be, is not just if they're valid, but what level of responsibility flows to the town manager based on what's in there. So assuming it's all fact, what's the responsibilities and how do they lie, in your opinion, versus our town charter versus et cetera?
Is that, are you comfortable doing that, or?
Yeah,
I mean, I don't want.
It's a fine line I'm walking, but I'll-
I don't want
Oh, I
to
know,
put you in a
that's
position of making
why-
the board's decision.
Well-
That's what
No,
I'm struggling
no.
with.
That's the whole reason we're asking you.
Why don't we try this, is I have a sense of how to proceed. I'll draft something, it'll go to the board. If board members have additional questions, obviously, as I said, they can ask me without copying other members or involving other members or talking to other members. And then we'll go from there. I just want to make it clear, it's not my role to say whether the manager should or shouldn't be disciplined, whether I think, it's really likely going to be, if you believe,
XYZ.
X, Y, Z, then you would proceed. If you don't find that, there's a responsibility with this, then you would not. So
So
I'll put that in some.
it's guiding our thought process, not you telling us what your opinion is.
That would be what I'm
Which is what I-
suggesting.
And can you also do, if you
Yes.
believe in XYZ, so this is how you would proceed?
Certainly, yes.
Because, again, I'm just looking for wording and formality. I don't want to trip on formalities here.
Understood.
And and on the flip side, if you don't believe then this is how you proceed.
Right. And I'm comfortable with that to help the thought process. I'm not comfortable asking him to give an opinion on
No,
what we
I'm
should
not
be
either.
doing.
I'm
And
with you.
I get what you're
Yeah.
asking.
Yeah,
I just wanna
and
make that
with a
clear.
real eye towards the town charter and the responsibilities of the town manager. Where does it lie in this whole thing?
Yeah.
Because that's the irony, is there's no argument about the communication. That happened.
Right.
There's no argument about the decision. Excuse me, Sarah made it. Okay? It's just, how does it apply to discipline with regard to the town manager? That's what we need guidance on.
All right, we
Are you
go.
okay with that? Everybody?
Yeah.
Any other comments? So it's 3:22, and I will entertain a motion to continue this discussion to Wednesday, October 12th at 9 a.m.
I'll make a motion to continue this meeting to October 12th at 9 a.m.
Second.
This, I can do a regular, we're not in executive. All those in favor?
Aye.
Aye, 5-0.
That's right, we're in open session, that's right.